Namaste, Jai Hind, Vande Matram. Welcome to this edition of The Right Stand. I'm Anand Narsimhan. The Madurai Deepam controversy has rapidly escalated into a complex and contentious dispute involving religious rituals, constitutional rights, executive authority, and the role of the judiciary. Central to this dispute is the annual Kartigai Deepam festival, celebrated on the Tiruparankundram hill in Madurai, which has now become the focus of legal battles, political tensions, and public protests. The issue began when a religious ritual that has been practiced for centuries, the lighting of the Kartigai Deepam at a specific site on the hill. Now, traditionally, the Deepam has been lit at an ancient stone pillar called the Deepatun, and a site associated with the festival for generations. However, the Tamil Nadu government suggested moving the ritual to a pavilion near the Uchipilliyar temple, that means the higher Ganesha or upper Ganesha, citing concerns over public order and logistical feasibility. The Tiruparankundram hill is a shared sacred space, home to both the Arulmigu Subramanya Swami temple and the nearby Sikandar Badusha Dargah. Now, the Sikandar Badusha Dargah dates to about 150 to 200 years old. The Deepatun has been proven by the Archaeological Society of India in the past to be at least from the time of the Nayakars or the Sangam period, and the temple much older than that. Now, the proximity of these religious sites has made the controversy sensitive, with some claiming that the moving the ritual might stoke communal tensions, while others insist on preserving long-held traditions. Now, on the 1st of December 2025, the Madras High Court, in a landmark ruling, directed that the Deepam be lit at the traditional Deepatun site. And this order came after a petition was filed by local devotee and religious leaders asserting their right to follow age-old customs under Articles 25 and 26 of the Indian Constitution, which guarantee religious freedom. The court's ruling was met with resistance from the Tamil Nadu government, and however, the Madras High Court stood firm, stating that judicial orders upholding constitutional rights must take precedence over administrative objections. So the division bench also ruled in the petitioner's favour and upheld Justice G.R. Swaminathan's judgment. Now, in subsequent hearings, the court reinforced its position by allowing the petitioners to proceed with the ritual under the protection of the CISF after devotees were blocked by the state government after the first ruling. Now, at the hearing that went on and the proceedings which continue in court, there are some key takeaways. Tamil Nadu government is now questioning the existence of the Deepatun itself. And the Tamil Nadu government questions necessity of lighting the Deepam itself. The Tamil Nadu government says petitioners have no legal right to light the lamp at the hilltop. Tamil Nadu government says Article 226, the court's power to issue direction, can't be used to change customs. Tamil Nadu government further says the original plea is not a public one but a private interest litigation. Madras High Court to Tamil Nadu government, what's the problem in lighting the Deepam on the hill? They ask. Now, this flies in the face of records from the Tamil Nadu government itself, where a book by L.J. Bose, published by the Tamil Nadu Archaeology Department back in 1981 viewers, mentions the Deepatun bearing Deepam. It says the Deepatun is en route to the hilltop, closer to the Shikhara, built during the era of the Nayakars, with sculptures depicting Hanuman, who's looking left away. The arms are raised and the face is turned towards the left. It says lamps can be lit on the Tun, adding that it is customary for bhaks to light lamps on the Tun during Kartigai festival and this entire month, especially around the Kartika Purnama. And it is done by those who have done Punya Karma. Now, so where do the questions arise in the court? Now, the INDI bloc, led by the DMK, Congress and the allied parties, moving an impeachment motion against Justice G.R. Swaminathan, who spearheaded the ruling and wrote down the orders. The motion was submitted to the Lok Sabha Speaker Om Birla. Over 100 MPs under Articles 217 and 124 of the Indian Constitution, which govern the conditions of service and removal of High Court judges. The MPs have accused the judge of misconduct, alleging his judicial conduct raised serious questions regarding impartiality, transparency and adherence to secular principles of the Constitution. But this has been countered by over 50 former judges who have hit out at what they call is political targeting of a sitting judge. They call it a brazen bid to browbeat judges who don't fall in line with expectations. If attempt permitted, it would cut roots of our very democracy. Reasons mentioned, taken at the face value, are wholly inadequate. During emergency, the then government targeted judges for not towing the line. Our judiciary has stood the test of time and withstood all pressures. Move not isolated fits into a pattern of discrediting the judiciary, attempt to weaponize impeachment and public calumny as instruments. But now it seems the impeachment case against the judge is weak, As per the letter of the law, judicial ruling of a judge wouldn't count as misbehavior. The claims in the motion aren't backed with cogent evidence. The same might not pass high standards prescribed under the Judges Inquiry Act. Motion might not pass Speaker's gatekeeping if it doesn't disclose specific instances. The impeachment isn't an option to set aside the judgment of a judge. The question remains as we sum up these facts. Did the state jump the gun? Is the state overtly bending backwards to appease a certain section of society who in 2005 have largely come out and said we don't have an objection as long as the Deepam is lit 15 meters away from the Dargah. T.R. Ramesh, lawyer and activist with us. We go to our other guests also, Anil Anthony, spokesperson of the BJP, Ishkaran Bhandari, lawyer, Pulla Rao, political analyst, and S. Balan, leader of the left. My namaste, Jai Hind to everybody. Thank you for your time. Vande Mataram. T.R. Ramesh ji, one aspect is they are now questioning whether this is a Deepatun or a survey pillar. And they have sent the ASI back again. Even as you are planning to move a PIL against the HRNC department and its presence at the temple itself. Go ahead, please.
Yeah, okay. The book cited by you, authored by one Mr. Bose, who is an archaeologist himself, clearly mentions the Devatum and the practice that was prevalent. So, I don't know what the government is going to say about it later on. Today, three senior counsels argued for the government side, and I have great respect for them, just as Senior Counsel Masalamani said he has great respect for G.R. Swaminathan Justice. The Senior Counsel Masalamani, when he spoke, he said the executive officer has considered the petition of the Ram Ravi Kumar who filed a case and said the Deepam will be lighted only the Uchipaliyar temple. In the first place, the executive officer has no role in religious matters. Of course, the executive officer is functioning there by fraud on statute. He was appointed by segregating Meenakshi Sundareswara temple and this temple by filing false affidavit by the HRNC department. They obtained an order by fraud. Assuming for a minute that there is an executive officer validly appointed and is there validly present, even though under the law, executive officers become functus officio after 5 years. He has no powers to decide anything on religious matters. In the HRNC Act, there are two sections which start with the words, nothing contained in the Act. The words, nothing contained in the Act is more potent than notwithstanding anything contained in the Act. There, under section 105, the Act, of the Act, it says, the officials of the HRNC department have no powers to decide anything to do with religion, the tradition, and the customary practices. So how can an executive officer decide this? So this is a very frail argument. I'm surprised. The learned advocate general appeared. Senior Counsel Masalamani appeared, and I think Mr. Senior Counsel A.K. Sriram appeared. But they are all missing one fundamental point. The executive officer there has no role. He's a person non-est, and he cannot decide religious matters. The case is very simple. An established tradition for centuries, which was stopped in between due to various reasons, and which was started after 1931. The Privy Council judgment, we will show proofs that it happened after 1931. It cannot be stopped. The court has only revived it. It is a traditional ritual. It has all backings and records, and this is not something coming out of thin air.
See, the 1996 judgment also, and we'll put out some of those excerpts just quickly, also says that you can light the lamp anywhere in the temple and its temple property as long as it is more than 15 meters, 15 meters away from the Dargah. In 2005, an NOC has been given by the Muslim Paksh or the local Muslim groups there also. According to Professor Gurumurthy, the issue was of about, sacrificing goats around Bakari time at the Dargah, and they said this is temple land and you cannot do that. So I think the Muslim Paksh has agreed there also that this will not be done. This entire, so there has been, it's been amicably settled. The larger issue is contempt of court. Mr. Balan, if a court passes orders, it's not even about moving to impeach Justice Swaminathan. If a court has passed orders, you have to implement the order even as you challenge it in a higher court. Here the state has not even implemented the order. It's brazen contempt.
No, see, I can't give you one word answer. See, it has a cherished history. The persons who are backing Justice Swaminathan should also remember what they have done in the Sabrimala judgment of the Apex Court in the year 2018 and what they have done in Kalyan Singh government assuring the Supreme Court. Many such Supreme Court, High Court orders has been violated by the Sangh Parivar. That's number one. Number two, Mr. Swaminathan, Justice Swaminathan, unfit to be a judge of a High Court because he has communal agenda. Number two, see this, the website of RSS, this Sikandar mountain is shown, which the RSS has been planning to create it as a communal issue in Tamil Nadu. All the Sangh Parivar leaders, including the state leaders, say that they want Ayodhya in Madurai or in Tamil Nadu. They are looking for a communal agenda. What I mean to say is, Justice Swaminathan is known for affiliating himself with the Sangh Parivar, not only with his mindset, but also with his attire.
Sir,
and he is like,
sir,
sir, wait,
when a former judge in the Supreme Court, when a former judge in when a former judge in the Supreme Court openly profess 1 minute, sir. 1 minute, sir. Mr. Balan, did you move an impeachment motion against a former Chief Justice of the a former Justice of the Supreme Court who was openly a member of the left? Whose family member was a Politburo member of the left. So at that time, political ideology and leanings did not count. When they were attending, when a former judge, did you take umbrage? Sir, did you take umbrage? Did you take umbrage when a former judge was found at the feet of a former Chief Minister of the state of Tamil Nadu and got elevated? At that time, did you take umbrage,
I can
sir?
also quote.
My simple point is, sir, you have to first question, irrespective, sir, who is in government, who is in power? The state is, sir. The Sangh Parivar is not in power. 1 minute. 1 minute, sir. 1 minute, sir. There are judgments of Justice Swaminathan against which the members of the RSS and Hindu groups have protested when he ruled in favor of a book being released that actually questioned and maligned the intent of women who are going to pray at a nearby temple and the customs that were found. So do you forget that? My question, Mr. Balan, is it's very simple. It's very simple. Does this pass the test? Does his judgment pass? 1 minute, sir. Does his? Do you know? You are the one who's creating friction, sir. Because the left government in Kerala allowed women who do not believe in Ayyappa to try and march into the sanctum sanctorum. Will you do that, sir? Will you do that, sir? No, sir. No, sir. No, sir. It is a rule. Sir, rule. No, women don't. So then why don't you argue the same for women in Sunni mosques, sir? Why don't you argue the same for women into Sunni mosques? You don't say that. So you have double standards, sir. You have double standards. No, stand here and say that Kerala government should allow women into Sunni mosques. Say that Kerala government should allow women into Sunni mosques. This is the hypocrisy of the left. So in this case, the right to pray and 1 minute, sir, Mr. Balan, the right to pray. No, you are creating, sir, because the right to pray, the right to profess religion, the right to practice religion, and the deity having perennial civil rights and living rights is something which is enshrined in the constitution, and that was denied, sir. Even here you are saying Skandar has become Sikandar. The mountain belongs to Skandar, sir. Not to Sikandar. The mountain belongs to Skandar, and it is enshrined in the records of the Tamil Nadu state government. All right, Mr. Balan, 1 minute. I'm going to go across to Justice S.N. Aggarwal, former judge of the Punjab and Haryana High Court. He's with us. He's one of the signatories of this letter that's been written. Justice Aggarwal ji, namaste. Jai Hind. Thank you for your time. My first question to you, does the judgment and the ruling of Justice Swaminathan pass the test of judicial reasoning?
Yes, he was absolutely right to pass any judgment which is according to law is correct.
So, can an impeachment motion be moved because some groups believe he has a different thought process or he professes a certain political or religious ideology or thought process?
Absolutely not. The remedy available to him to go in appeal, and if the appeal has, in this case, appeal was also dismissed, and this order was upheld. And if thereafter the party is aggrieved, they should go to the Supreme Court. Moving contempt matter doesn't lie in under the Constitution.
So, is there any ground for this entire impeachment motion? How do you view this impeachment motion? It's a very strongly worded letter that you have signed, so I would like to understand your thoughts, sir.
I say it's 100% wrong.
Why do you say that, sir?
The movement of this impeachment motion is 100% wrong.
Why do you say that, sir?
Because there is a remedy available. If Justice Swaminathan's judgment was not to the liking of any person or any community, they could go in appeal.
Also, is the
nobody
please,
for
please.
the last 80 years since we have achieved independence, no such incident is there. Impeachment was made against Swami Ramanathan from our High Court, Punjab High Court. That was on by the constitutional authorities. Similarly, now Justice Verma is also under impeachment because that is also under the regular procedure. If everybody has a right against a judgment to file impeachment, the parliament would be filled with the impeachment motions.
Will this also not perhaps put undue pressure on the judiciary, on the judges? That they will have to think about the political impact before passing any judgment?
No pressure on them. If somebody feels that he has under pressure, he can write to the higher authority, to the Supreme Court, that this judgment, the judge has delivered the judgment under pressure.
No. What I'm saying is...
complaint can be made.
What I'm trying to say is these impeachment motions, will they put undue pressure on judges and color their judgment or their interpretation of facts?
Yes, 100% is a virtually amount to threaten the judiciary. It amounts to threaten the judiciary. And for this purpose, I think these people can be hauled up who have moved it. They have adopted a procedure of their own.
True.
No such remedy is available.
Ji, please complete.
Hanji.
Please complete.
No such remedy is available to these MPs.
But with more than 109 MPs trying to sign this, what does this smack of, Justice Aggarwal? Does this bring back the times of the emergency when judiciary was overpowered and rulings were...
It is virtually like the lawlessness. You can say to the lawlessness that people are not following the Constitution of India. Where the procedure has been prescribed in the Constitution that a judgment can be, if decided this way, the 156 or 143 MPs would stand up and file the contempt petition. No procedure in the Constitution of India. Proper procedure has been laid down when the things can be moved, by which way. If the party is aggrieved against the... Now judgment, Swaminathan has passed a very proper judgment that in a temple you have a right to create a jyot.
In fact, Justice Aggarwal, I'm given to understand that Justice Swaminathan, and this we heard from the petitioner's lawyer, that he physically went to the place,
हाँ
he measured the distance because 1996 के judgment में लिखा हुआ था कि 15 मीटर की distance होनी चाहिए. So he has physically measured the distance of the Deepa Stambham from the Dargah. It's come to more than 15 meters, and then he has said there is no problem if somebody, and also in the first case, he has not said that the petitioner can go and light the lamp. He said जो temple के authorities हैं, जो HRNC department है, he has directed them that आप जाइए और आप दिया जोत जला के आइए. You go ahead and light the lamp and come. That's his first order, and that has also not been implemented by the state.
No, that is absolutely right. The state is under duty to implement that order. If they do not it, they violate the Constitution of India. And then they file a review petition. Review petition was also dismissed by Justice Swaminathan. Then they went and appealed. The order of Swaminathan was upheld by the division bench. The further remedy to them was to go to the Supreme Court. But moving constitution, the people, DMK people are very wrong people. The other days they were blaming the Sanatan Dharm people who said like malaria or something. Their own countrymen, if they blame us, Pakistan said that we have also right to call you malaria. The people of such a small buddhi, they don't have a right to rule the state.
My other question
And
is,
मैं आपको ये
जी,
भी बता
जी बोलिए, प्लीज आप बोलिए, आप बोलिए.
हाँ, नहीं मैं तो यही कह रहा था, रिपीटिंग द सेम थिंग.
तो मेरा प्रश्न आपसे एक और है सर. Should the court not also issue commence contempt proceedings against the state government? If the state is going to go and show this
They
impunity, shouldn't the courts turn around and say you are in contempt not once but twice?
Swaminathan, I think, did issue the notice, contempt notice. And the parties, then they aggrieved, came to the speaker. Now, supposing one or two MPs had come, we could have said that he should be thrown in the jail. But now 156, the whole people have gone mad. After all, courts have to work and courts have to decide. Supposing now, right from the lower judiciary up to the High Court, and then Consumer Commission, I may have decided 550,000 cases. And if in every case they file a contempt against me, or they file this impeachment motion against me, then how will I be able to decide the case? I think they are misguided people. They don't, virtually they say move against the country.
Justice Aggarwal, my final question to you, what would you urge the speaker to do? Would you urge him to throw this motion out immediately without considering? Because admission also would set a different precedent.
Yes.
Ji, please.
No, I would advise if somebody asks me, if the speaker asks me, I will request him to throw away this impeachment motion and tell the people that go in the appeal. If everybody comes in impeachment against the judgment, where the law lies? Speaker in his own wisdom should reject this impeachment motion, that it is not for us to deal with go to the judgment. If you are aggrieved against the judgment, follow the law. And law is there in the Constitution.
True. Fair point, sir. Justice S.N. Aggarwal, I thank you for your time and thank you for being so candid and being open about what the law states and what should be the correct procedure that should be followed. I thank you for your time, sir. Thank you, sir.
Thank you, Ji. Thank you very much for... now, can I see this in the TV?
Yes, sir. Sir, you're on TV only. You're live on air. We've just put this out on...
no, that's right.
Yeah. Yeah, please go ahead.
But kindly send me the link then.
Okay, sir. We will do that. We'll do that, Justice Aggarwal. We'll send it to you. Thank you very much for speaking with us. So Justice S.N. Aggarwal clearly upset with the way things have gone out and the way the Tamil Nadu government has conducted itself, saying this is an open brazen bid to threaten the judiciary. Anil Antony with us, Ishkaran Bhandari with us, Pula Rao with us, S. Balan with us. Thank you for your patience. Had to go across to Justice Aggarwal because he joined us and in an exclusive conversation. Anil Antony, how would you want to respond? Saying the BJP is trying to polarize, RSS is trying to polarize, terrorize, communalize, or is it the state government that is in brazen contempt? Go ahead, please.
Thank you for having me in the show. Now, the elections are coming in Tamil Nadu, and something which we are seeing repeatedly in state after state and election after election time is the India Alliance members. It doesn't matter which one it is. It's the Congress sometimes, DMK sometimes, Communist Party sometimes. They are taking these polarizing positions, which is anti-majority, anti-Hindu, just for certain vote bank politics. You look at this Tirupparam hill also. The Kartigeya festival is something that is going on for centuries. Like, it is not a new thing. We spoke about the book by Mr. Bose. But you look at historic records, like there are copper plates from centuries back. There were hymns from like almost 8-9 centuries back, which all mentioned about this particular festival, and it is going on for a long time without any disruption. Now, suddenly out of the blue, like again, the opposition parties are blaming BJP, etc. But here the Bharatiya Janata Party has absolutely no role in this at all. It was a third-party person, a devotee who went to the court and said that there are some disputes regarding the site of lighting of the lamp. And a single member judge very clearly, after you rightly said, like he went to the site, he measured the distance from a dargah, and based on a 96 court order, he gave a very clear order that this particular lighting of the lamp, which was suggested by Rama Ravindran, who was the petitioner, is outside the 15 meter and it is permissible, and he gave an order. And then now what we are seeing is a clear contempt of the court, first of all, and then again, once again, wherever many of these parties, the India Alliance members, they are in governance. They are only in some states, but wherever they are in governance, this is a very, very clear attempt to stifle the law, and it is a very clear attempt to bully people who are not towing their line of their certain beliefs. And here a judge is being victimized, where the judge very clearly, after looking at proceedings for in the past, after looking at previous court orders, have given a very reasonable order. And the judge is now being threatened and intimidated with even an impeachment motion. What we are seeing is blatant vote bank politics. First of all, it is again blatant anti-majority, anti-Hindu politics also, regarding a festival that is going on for centuries in a very undisrupted manner. So in an election year, once again, this is an attempt to polarize. But you have already seen in many states where when similar kind of strategies were chosen by the India Alliance members, the voters have reacted very overwhelmingly and convincingly, where they are very clear that we don't want this kind of politics. And this is why the Bharatiya Janata Party and NDA had won record number of elections also. Plus Tamil Nadu also, we will see the NDA coming back. We will have an NDA government because the people of that state and the Bharatiya Janata Party has nothing to do with these kind of controversies. This is created by the DMK just for appeasement and vote bank politics. And this is anti-Hindu, anti-majority politics that we are seeing.
Okay, more than one people have said, Pula Raoji, that the locals had already settled this matter. And even the first order of the court, you would appreciate, did not tell the petitioner to go and light the lamp. It told the HRNC official to go and do it. And they refused. Had they done it that day, this matter would not have escalated at all.
No. One thing is very clear, the Supreme Court doesn't think this is of any urgency. I think the state government went to the Supreme Court and the Supreme Court hasn't given an urgent hearing. Doesn't think it's of any urgency. It has treated it with a certain kind of view. Therefore, things will cool down and the Supreme Court will take all the points you mentioned, one by one. But, the other larger issue, which we just had Justice Aggarwal talk about, impeachment, this is a separate issue. I may humbly say he was he kept on saying that it is because of the judgment he is being impeached. It's not because of the judgment, as the impeachment notice says. I didn't draft it. I read it just like you. And they said the judge, for his conduct, whether the speaker will accept it, throw it out, and other remedies, that's the second matter. The main thing is the impeachment was not for the judgment, as Justice Aggarwal kept saying, unless I heard wrong. So these are issues now. And the Supreme Court on such issues, see, first of all,
by endorsing the conditions on which
start coming to force
Pullarao ji,
because the Supreme Court is looking at it.
would have appreciated.
Moreover, Supreme Court would have given urgent hearing if it was a life and death matter. They say you can take time.
No, sir. Don't make the matter of faith a matter of life and death. You have to use your words very, very carefully. The people the people who have escalated. See, the matter before the Supreme Court. The matter before the Supreme Court has to be the matter of contempt. The fact is that the state government has not even bothered to respond to the contempt of court notice. It has shown brazen disregard to the Madras High Court. That's what it's done, because it's not just Justice Swaminathan. The division bench has also, two-judge bench has also upheld the judgment. And they are in contempt and disrespect of that. Now what it smacks of, sir, is that those who call themselves liberals are showing brazen intolerance. Those who call themselves and try and quote the Constitution, that the Constitution and the rule of the law is equal to all, are trying to say that we can decide how Hindus have to worship, where Hindus have to worship, where Hindus have to light a lamp, and how Hindus should pray. That's what it is. They will not say this of any other non-Hindu faith, be it Sabrimala or be it Tirupuran Kundram. It's just the brazen way of trying to turn around the laws of the land against what the Hindu faith believes and what is their right. Skandar has become Sikandar. That is all right. And the law, the court says 15 meters away you have a Deepatun, and the government of Tamil Nadu in the past has said this is a pillar that existed 400 years and we've proven this. It's a Deepatun, it's not a survey marker. This government is coming back and raising that same argument again via its Advocate General today. What is this going on other than that? Other than the state trying to be brazen to say that no, we will disregard anything that is not subscribing to our line of thought. So who is intolerant here? Ishkaran Bhandari.
Yeah. There are some larger issues in this as well as a specific case. Nobody can speak better on the facts and the law than Mr. Ramesh, who has already spoken, and my naman to him. But I want to see what is the attempt being made here. That is very important to go into. It is a dark threat on the judiciary's independence when you try to move an impeachment motion because of an order of a court. And this is not the first time. I want to give you two examples where the court spoke for the fundamental rights of citizens. One was the Keshavanda Bharti case. Immediate consequences. The party in power then superseded 3 judges to make another person as the Chief Justice of India, upsetting the precedent. The second example, when another brave judge, Justice Khanna, spoke up and said that you have Article 21, the state cannot take away your life even though it's emergency, again superseded. So we had those two dark examples which can be matched only with the recent conduct, where you don't like a Chief Justice of India, Justice Mishra, you move an impeachment motion against him. Same way, there is an order of the court. I will not go into the merits of the case. There is a constitutional scheme. Once an order has come, we are not before an order that we can give our interpretations, our arguments, our selective facts, whether it is 200-year-old, 400-year-old. You quoted a book which establishes it, but we don't need it. Once you have an order of the court, all that stands established already. Then all that the government has to do is to obey that order. If it does not, it leads to a breakdown of law and order. It leads to a breakdown of the constitutional scheme of governance. The only remedy against an order of court is to appeal it. They did appeal it. They did not get relief. Then is to go to Supreme Court. And we heard a backward interpretation today that the Supreme Court is not thinking the matter is important. What is the law of the land? That if an order exists, unless it's stayed, it has to be implemented. The other version could be the Supreme Court did not think there is anything in that order which needs immediate examination. But we are not to presume what the Supreme Court is to do. We are to presume what is the order standing today. The order standing today is that you have to implement it in this manner. If the state officials, and that is why the high officials of the state have been summoned or have been issued a notice, I believe, because you are not complying. So this is the danger. Let me put it in a nutshell. The danger is that if anything goes in favor of Hindus, anything which establishes Hindu right based on a judgment of court, even then you don't want to implement it. That is the grave danger which must be addressed, I hope, by the division bench.
But the law is supposed to be the same for everyone. Article 25, Article 26, Article 14, all these articles do not take away the right of any particular person and supersede that with the right or interest of any other person. Most importantly, Mr. Ramesh, is this not established that all communities were in agreement and there was an agreement reached how this will be done? So why is the state trying to supersede that?
When it, we have heard the expression that making a mountain out of a molehill. The current DMK government is trying to make a molehill out of a mountain. This is a holy mountain, and there is a Privy Council judgment which says almost all of the entire hill belongs to the Devasthan, except place where the Dargah is. We already talked about it.
Yeah.
And 15 meters away from the Dargah, none of the Muslims objected, and they passed a 144 order prohibiting people. But 144 can be passed only if there is a tension, communal tension between two communities or two sects. There are only Hindus coming to the temple entrance and asking the Deepam be lit. The Muslims had not gathered that. These Muslims had not come out in opposition. So this is something, a story, which the DMK government is making to show themselves as the only protector of the minorities. They want to set a narrative for the coming election. Nothing more, nothing less.
Christians plus Muslims in Tamil Nadu, last I checked, was more than 21% vote share.
Well, the census might say something else, but the figure you say could be that much. The Christians and Muslims, especially the Christians, many of them do not profess Christianity as their religion in the records.
Now that is another comment that's been made by the Madurai bench of the Madras High Court, that is about crypto Christianity, but that's a different issue altogether. But this is a group.
Sorry, but
this is a grouping.
Truth.
Yeah. No, but this is a grouping which is being targeted, and if this is not appeasement, then what is? Yes, Ishkar and Bhandari have to wind up. Yes.
No, just one thing, because the argument of communal harmony is being given all the time. Communal harmony does not mean butchering our own rights, especially after the court has established something. So the burden of communal harmony cannot always be on the Hindu, so that A, the government does nothing for him, he goes to the court, he gets a judgment in his favor, then also the government, throats it, does not implement it. This is a test case. The will of the court, the judgment of the court must be implemented in letter and spirit. Otherwise, we are going back to the era of supersession of judges or attempts to intimidate judges.
Who's the intolerant one here, Anil Antony? The RSS. Because they're vitiating the atmosphere through its fronts, BJP, Hindu Munani, etc. That's the allegation.
We are seeing it again and again. Whenever the left is in power anywhere, there is absolute intolerance towards any dissenting voices, and then they claim to be liberals and they claim to be progressives, etc. This is something which we are seeing across the world, where certain terms are being used in a euphemistic manner to mask their intolerance. In Tamil Nadu also, the BJP and the RSS is nowhere in the picture. It was a devotee who went to the court and petitioned the court. It was a judge who gave a verdict based on historic precedences. And here there are, even the Muslim community is not against this order. There is no Muslim who is against the order. The Hindus are, they are telling that this is something historic. And here, just for vote bank politics, unfortunately, you are seeing that DMK create this polarizing situation just in the verge of an election.
Right.
But like I said before, like this has been a strategy that has been tried and tested by the India Alliance members in many states, and they were repeatedly rejected by the people. I'm very sure that the people of Tamil Nadu also will see through this polarizing politics, and they will ensure that a actual party that stands for everybody, Sabka Saath, Sabka Vikas, Sabka Vishwas, and NDA government is coming back in Tamil Nadu in April, May 26.
Well, it is up to the voter there. Right now, it is about the faith and the faithful. The simple part is you have to see the proceedings in court. In fact, Justice Swaminathan ensured that the Muslim Paksh was also party to the hearing, despite the fact that they were not involved at all. He consulted them also. He consulted the judgment. He asked the state. And most importantly, he didn't tell the devotee to go and light the lamp. He didn't go and tell the petitioner to go and light the lamp first. He told the HRNC officials, you do it on behalf of the devotees. And even that prayer was agreeable to the petitioner. They just said, allow us to complete our tradition. That's what they said. That's where it is. I've got to wind up on that note. Thank you very much to all our guests. Quickly move.